Welcome to this overview of PennDOT's Publication 740. This video tutorial will focus on Chapter 5, Right-of-Way Phase. Various state and federal laws, regulations, policies, and procedures for the acquisition of right-of-way apply to any project that uses state and/or federal funding in any phase of the project. It is vital that all state and federal regulations are followed in order to not jeopardize funding. There are many different scenarios under which the right-of-way process can occur for a project. This table briefly outlines the most common scenarios. Let's take a look at each one in greater detail. Scenario A. Projects involving local highways, not state roads. Local highways include any public roadway and/or bridge owned and maintained by a county or local municipality. The local project sponsor is preparing the right-of-way plan and acquiring all of the necessary right-of-way for the project. In this scenario, PennDOT will not be signing the right-of-way plan. Scenario B. Project must involve only local roads, no state roads. The local project sponsor is preparing the right-of-way plan, but PennDOT uses a contracted consultant or the PennDOT right-of-way unit to complete the appraisals and acquisition services. Only pre-approved right-of-way appraisal and acquisition consultants may be used. In this scenario, PennDOT will not be signing the right-of-way plan. What differentiates Scenario A from Scenario B is that appraisals and acquisition services are performed by the local project sponsor in Scenario A, while they are performed by PennDOT in Scenario B. Scenario C. Project must involve only local roads, no state roads. The local project sponsor is preparing the right-of-way plan, but the PennDOT right-of-way unit or pre-approved consultant is acquiring the right-of-way on behalf of the local project sponsor. PennDOT will then be reimbursed under the local project sponsor reimbursement agreement. If a declaration of taking is necessary, it is the local project sponsor and not PennDOT who must perform this action. Although not a legal requirement, the district may wish to have the PennDOT district executive sign the right-of-way plan since it will be PennDOT personnel providing right-of-way services. Scenario D. Specialized process for PennDOT acquisition for local roads and projects. Under this situation, the project is not limited to only local roads. Projects using Scenario D may also have some right-of-way requirements along state roads and/or bridges owned and maintained by PennDOT. In this scenario, the local project sponsor is allowing PennDOT to conduct all right-of-way services on their behalf. In order to allow this to occur, the project reimbursement agreement should be prepared and executed. Next, a resolution should be prepared and executed authorizing PennDOT to execute all required documentation on behalf of the local project sponsor. Last, an ordinance must be prepared and executed within 90 days of the signed project reimbursement agreement delegating the Secretary of Transportation to acquire right-of-way necessary for the project. The cost of this service and the acquisition will be an eligible project cost. Under this scenario, the right-of-way plan title sheet will be signed by the PennDOT District Executive, Deputy Secretary, and Secretary of Transportation. In addition, the ordinance number and authorized county official information is included on the right-of-way plan title sheet. Once all requirements are in place, Scenario D will allow right-of-way appraisal and acquisition to be completed by PennDOT as it would on any PennDOT project. Information about the plan preparation should be requested from the PennDOT Central Office. Please note, the Secretary of Transportation does not need to sign any right-of-way plan that does not acquire right-of-way for the state highway system. The first step of the right-of-way process is the development of the right-of-way plan, which must be created and, once approved, recorded at the local courthouse prior to acquiring property and easements. Right-of-way plans must define the type of interest to be acquired in accordance with Publication 14M, Design Manual 3. It should be noted that right-of-way plans can take several months to develop. Be sure to build adequate time into the schedule to allow for development of the plan. Note that occasionally, on local projects, the right-of-way plan has been developed concurrently with the environmental approval documents. Acquisition can only begin after both environmental approval and recording of the final right-of-way plan. The first step of acquisition requires a written appraisal and can be time-consuming. Appropriate time for the appraisal process must be carefully factored into the project schedule. The PennDOT District Right-of-Way Unit can provide estimates of the time needed to complete the acquisition relocation process for a project. appraisal, and appraisal review procedures are detailed in PennDOT's Publication 378 Right-of-Way Manual. Appraisals must be completed by certified professional staff or fee real estate appraisers selected from PennDOT's list of approved appraisers. The appraisal process begins with the project damage estimate, which is followed by the appraisal problem analysis, the fee appraisal, and the appraisal review. A project damage estimate is an estimated acquisition cost for each claim identified on an approved right-of-way plan. Every appraisal requires documentation, the appraisal problem analysis, to support the appraiser's stated opinion of value. The format and level of documentation for an appraisal depends on the complexity of the appraisal problem. In uncomplicated cases, the appraisal problem will allow that minimum standards be used, while other complex cases may require a detailed appraisal. An appraisal problem analysis (APA) outlines the scope of the appraisal assignment and must be completed for every appraisal that is expected to be complex in accordance with Publication 378 Right-of-Way Manual. The fee appraisal and appraisal review are conducted by independent professional staff and fee review appraisers to ensure that offers to property owners are based upon properly prepared and well-documented real estate appraisal reports. Property acquisition follows recordation of the final right-of-way plan and the appraisal process. Acquisition involves direct personal contact with the people affected by the project. The primary goal is to acquire property interests through negotiation rather than through the use of condemnation. For this reason, negotiations must be conducted by individuals through personal contact with affected property owners. Personal contact must be followed by prompt, written offers and sufficient time for the property owner to consider the offer. Please note that the rights of property owners are outlined in Publication 83, when your land is needed for transportation purposes. Negotiations must in no way coerce property owners to settle. The agreed purchase price must be paid before requiring the property owner to vacate the property. At times, negotiations are not successful and eminent domain proceedings must occur. The process starts with the filing of a declaration of taking, DT, on the property. Filing a DT automatically vests title with the acquiring agency. During any eminent domain proceedings, particular care must be taken to follow all procedures of Publication 378, Right-of-Way Manual, and the Pennsylvania Eminent Domain Code. Qualified legal advice is necessary when undertaking an eminent domain proceeding. In cases where the acquisition process results in the relocation of families and businesses, federal and state laws and regulations allow in certain circumstances an additional set of benefits and payments to assist persons in this situation. Applicability of these additional benefits should be determined in coordination with the district right-of-way unit. Successfully relocating residents and businesses requires careful planning. Family and business relocation adds considerable time to the project schedule and must be accounted for. Once all right-of-way impacts have been settled, including relocations, the project must obtain a right-of-way clearance certification. The certification process, including who is the approving agency, varies depending on project oversight status, type of funding, and who is doing the acquisition. For example, PennDOT or the local project sponsor. Proper documentation of the appraisal and acquisition processes, along with close coordination with the district office, will help ensure a smooth clearance process. Right-of-way clearance must be obtained before a project can be advertised for construction. The Uniform Relocation Assistance and Real Properties Acquisition Policies Act of 1970, as amended, commonly called the Uniform Act, is the primary federal law for right-of-way acquisition and relocation activities on federally assisted projects. Together, the Uniform Act and PennDOT regulations require that a local project sponsor maintain adequate chronological right-of-way records and files in sufficient detail to enable a reviewer to determine compliance with federal and state requirements. Records shall be retained for at least 21 years after each owner of a property and each person displaced from the property receives the final payment to which he or she is entitled under state and federal laws and regulations. Thank you for viewing this tutorial. The next video tutorial in this series will focus on Chapter 6, Utility and Railroad Coordination.